And conversely, if you do show you're prepared, they do appreciate that you are not making this difficult for them, that you did not just send in a big stack of paper and expect them to understand why you think that's significant. So that is one thing that you can prepare. And moving on to that next slide of being prepared to answer the question, where is that in the record? And I can tell you again, we've seen variation all over the place about how much ALJs want to see everything that you're talking about referred to in the record. Some don't want to even talk about it. They are more interested in, well, what was your thought process? Why did you think that this person was terminally ill? And hearing, some like to hear from people who actually cared for that patient and saw them and their personal observations, even if those aren't written in the record. There are others who really take the position, if you didn't write it down, it didn't happen, I don't want to hear about it. So again, you want to be prepared to the extent possible to support your statements with documentation in the record. And you want to be able, to the extent possible, to refer to specific pages. You can do that either if you've numbered the pages already that you've submitted. If you request the case file, as we've discussed in the toolkit how to do that, sometimes the judge will number the pages, and that can be helpful. Or if you can just say, please refer to the nurse's note dated this date. Those are all ways that you can point the judge directly to where you want him or her to look in the record. And so our next slide about considering how you're going to answer questions about your weaknesses. Once again, we can't tell you a judge is always going to fire away with questions. Some of them kind of just sit back and let you present your case. They might ask a few questions if they're confused, but they don't really get too far into it. We think it's helpful to prepare and assume that they will have at least read the redetermination and reconsideration decisions, and be prepared to say, well, no, this is why they were wrong, or this is why Maximus misinterpreted the LCD, or this is why Palmetto's decision, they were focusing on, they totally ignored the documentation here. And so being prepared, even if you don't want to necessarily bring those issues up, sometimes you might. Sometimes you might say, as part of our presentation, we want to make, clear why we think that they were wrong. But in some cases, you might not want to do that. But you should still be prepared to answer those questions. And then the next slide about selecting witnesses. And you're going to think I'm a one-track pony here, but again, there's no one way of doing this. We've seen it so many different ways. We've seen it where just the Director of Clinical Services shows up and is totally responsible for doing all the ALJ hearings. And there is, an advantage with the amount of experience that he or she gains over time. That person can become really effective. We had another client who had a really interesting innovation. She was the Director of Clinical Services and did most of the ALJ hearings, but she decided to bring the nurse who cared for the patient with her, depending on whichever nurse that was. And so then it was sort of an educational experience where that nurse had to go and look at her documentation to see where the weaknesses were and where it could be improved. And so, that was another interesting thing we've heard. When we do them, we like to have the medical director there. I think a lot of judges like to have the medical director there. They are the ones legally responsible for ensuring that the terminal prognosis is correct, and a lot of times what the judge wants to know is, well, what were you thinking? What was going through your mind that made you think this person was terminally ill? And sometimes it's just that simple, that it's not so much what's written down in a nursing note, it's, the medical director who can provide a summary of what were the factors that he or she thought were relevant to the prognosis. And so considering all those factors, you can decide who within your organization would be a good witness. Some people bring teams of people to the hearing. Some people bring just one person to be the spokesperson for the hospice. It really does depend. And then our last point on this topic is just preparing an outline. And that's just, we discussed that in the toolkit on pages 52 to 54, and just give you some guidelines. Again, you might go a different way with it, and that's fine, whatever you're comfortable with. But the point is, you want to, if the judge says, well, why do you think this claim should be paid? You want to have some sense about what it is that you want that judge to consider. This is really your chance to put forward your case and say, here are the things that are really important that you should think about. And so you want to be able to lead with your points rather than just expecting that the judge is going to ask you questions and that you'll answer them, which certainly can happen, but you want to make sure that you're leading with your position. And now we're just going to talk really briefly about some possible new trends in the future, and those are new contractors and new issues. And the new contractor issue is the RACs. And you might have heard a fair amount about them. They're getting some press. And the new issues that we're going to talk about are the ones called the Medicare coverage requirements. And that has not gotten as much attention, but when we talk internally, we see this as really a major issue that could be out there. It hasn't, neither of these things have had an effect yet on hospices, but there are things that in the future we want to be prepared for to the extent possible. It's not clear yet whether these, either of these are going to be game changers, essentially. Are these going to disrupt what we've normally experienced as hospices in the medical review and claim appeal process? But we want to think about them and think about what are the things we can do now to prepare for these possibilities. So who are the RACs? They are contractors. They are different than your intermediaries, and they were awarded contracts by CMS to audit all Medicare claims, including hospices. They started out as just a trial project, but they've now been expanded throughout the country and throughout all Medicare providers. So hospices weren't included in the trial project, and so we don't really know how are they going to look at hospice claims. Are they going to be just like an intermediary and focus on eligibility in the LCD, or are they going to focus on new issues? And again, they haven't started looking at hospice claims yet. They have, one of them has started to look at the claims from other Medicare providers, so like a hospital or a DME provider, for services they provided to a hospice patient that they coded were not related to the terminal illness. But again, they haven't started looking at hospice claims, so we don't know what to expect from them yet. In terms of why do people focus on the RACs and think they're so bad, well, they get paid a percentage of all of the improper payments that they identify. And so, at least in the trial project, people in those states, and especially